Hello, and welcome to today's webinar, Qualified Retirement Plan, Surviving the Ever-Changing Regulatory Environment, which is being presented to you by One America and Quarles and Brady. My name is Shelley Schumacher. My role at One America is that of Field Vice President of Key Accounts. I've been in the industry for more than 30 years, and I'm very pleased to be serving as the moderator for the panel today. I am joined by two individuals from One America and two individuals from Quarles and Brady as part of the panel. So what I'd like to do is hand it off to the panelists to introduce themselves. Mike?
Hi, good afternoon. I'm Mike Weaver. I'm a member of the Employee Benefits team here at Quarles and Brady. I come back to private practice after spending 19 years in-house with a record keeper TPA trustee, and I'm looking forward to chatting with you all this afternoon.
Thanks, Mike. I'm Dave Olson. I'm also an attorney with Quarles and Brady. I've been practicing employee benefits law for over 30 years, since 1985, specializing in retirement plan work and executive compensation. And like Mike, I'm very pleased to be here this afternoon.
Good afternoon. I am Jamie Kelly. I work as a Plan Solutions Analyst at One America. So I provide answers to questions on plan documents, plan administration, general compliance questions. I've been in the industry 16 years and have worked anywhere from a third-party administrator to a client-facing consultant, and now in the consulting department at One America.
And I'm Michael Ola. I'm with One America. I'm a recovering attorney, but I am currently the director of our Plan Solutions team. I work with Jamie and others. The team provides subject matter expertise to our clients and function as an internal resource to everybody at One America and their Retirement Services Division.
Great. Thank you, Michael. Before we get started, I just want to give a few housekeeping items. Today's presentation will be eligible for 1.5 hours of CLE credits. If you are an attorney and you would like to receive this credit, please fill out the form. It is located in the back of the materials, and those materials are in the webinar dashboard. We ask that you complete the form and return it to the contact listed at the bottom of that document. Additionally, if you are looking to have an HR certification, there is an HR form in the dashboard as well for you to use for self-reporting. We have muted all phone lines for those dialing in, as well as for participants listening to audio via their computer. There is an opportunity for you to send in your questions through a chat function. We will pause at the end of each subsection and pose those questions to the panel. So please use your chat function to send in any of those questions. We also want to let you know that the presentation is being recorded, and there will be an electronic survey that will be mailed after you after the program, and we will make this recording available to you at that point. Okay. With that, the agenda for today is to touch base and talk about some of the more recent legislation that is passed. We'll also spend some time talking about a few hot topics that have been discussed that aren't necessarily in regulation form yet. We will then segue into document and administrative failures and finish up with audits and investigations by the Department of Labor as well as the Internal Revenue Service. So with that, what I'd like to do is turn it over to Michael Ola to talk about some of the more recent legislation that has been passed, to talk about how that will affect you and your plan. Michael?
Thank you, Shelley. The reason we're talking about a couple of pieces of legislation here is that even though they were passed late last year and earlier this year, there's still a little bit of confusion with respect to the impact that they may have on retirement plans. And part of that is because we would like to see some guidance or regulations from the Internal Revenue Service, and unfortunately that is not forthcoming. So we want to talk a little bit about our understanding of where things are at this point in time. First, with respect to the Tax Cut and Jobs Act, which was signed into law right around Christmas time last year, it does have a couple of impacts with respect to retirement plans. First and foremost, and this is just a little bit technical, in that it changed the rules with respect to Roth conversions. It used to be that you could do a Roth conversion, and if you didn't like the tax consequences of converting pre-tax to a Roth feature, you had the opportunity with which to undo that. You cannot do that anymore. So Anybody who is wishing to actually do a Roth conversion should be well advised as to exactly what those tax consequences are before they can do it, because it will be final once they have done it. A little bit more applicable to retirement plans, though, are that particular act extended the plan loan offset rollover period, which is a mouthful. Basically, what that means is if the plan terminates or if a participant terminates participation or employment with the employer and then has a loan that is outstanding, most cases, the participant's not going to repay that loan. It's probably going to go into default, and that's a taxable consequence. The rules say, and the rules have always said, that if you've got the cash laying around that you could actually pay off that loan or roll over a like amount into an IRA, you could avoid those tax consequences of the defaulted loan if you did it within 60 days. The new act actually changed that so that you can do that rollover, if you will, all the way up until the tax return due date of the personal tax return of that participant. And that could be an extended period of time. So, for example, if somebody defaults on a loan because they terminated employment in January of one year, their tax return is not due until third quarter, roughly, of the following year. So it gives them an extended period of time with which to do the rollover. One thing I want to stress, though, is that this really does not have any impact on the operation of the plan. It is a tax consequence of that rollover of the loan. The only thing that we think a plan needs to do is to change their special tax notice. We've done that at One America with respect to the forms that we use to indicate that this rollover period is not 60 days anymore. It's actually until the tax return due date. So you may want to check those special tax notices to make sure they're up to date. There was a change in the hardship distribution rules. I'm just going to hit this high level because we're going to talk a little bit more about hardships later. What happened was Congress changed the definition of what's a deductible casualty loss. And that's in an unrelated section of the tax code that said if you have a casualty loss, you could deduct the costs of the loss that you incurred off your personal income tax return. And what they did was they changed that so that you can no longer actually deduct those casualty losses unless you suffer the casualty in a federally declared disaster area. So, for example, Hurricane Florence came through parts of the mid-Atlantic, and that was parts of those states were federally declared disaster areas. You could deduct casualty losses in that area. The impact of hardships is that most hardship rules indicated that a casualty loss hardship was for any casualty loss that was deductible under this other unrelated code section. So when Congress changed that code section, it changed whether or not you could take a hardship for a casualty loss. We think it was a technical error, but we haven't yet seen any movement to get it changed. Congress is not high on their priority list. So.
I'm not aware of any pending legislation either, but it will make a big change for people who think they, who think they've had something terrible happen, say, to their house. And historically, they would have been able to, let's say the tree fell on their house, they'd be able to come for hardship. And now, because it's not federally declared,
it's no longer hardship. Thanks, Mike.
Yeah.
We haven't seen this impact a lot of plans because we don't typically see a lot of casualty losses. But because of Hurricane Florence, we may start to see some from our clients who have participants in those particular areas. We'll see what goes. So the other act is the Bipartisan Budget Act of 2018. It was passed sometime in February of this year. It did a couple of things. First, it made it a little bit easier for the IRS to attach somebody's plan benefits if they owe the IRS money, and the IRS has always been trying to make it easier for them to get money from retirement plans. So if your participants or employees get an IRS levy, there may be some challenges from a plan perspective. But more importantly, this one did actually change the substantive rules with respect to hardships. Made it, we think, a little bit easier on participants and possibly employers with respect to hardships. What the changes did was it eliminated the rule that said you had to have a 6-month suspension from participating in the 401k plan. You no longer have to have that suspension. It allows qualified non-elective contributions, qualified matching contributions, and a variety of other sources of money within the 401k plan that used to not be hardship eligible can now be hardship eligible. And it also removes the requirement that participants take loans from the plan before they take a hardship. And that last one, I hate to say it, it was probably not as enforced as it probably ought to. The rule said that if the loan itself would increase the hardship, you didn't have to take the loan before you got the hardship. And a lot of people just said, oh, yeah, that would be too much of a burden. And, of course, they'd take the hardship. But you no longer have to do that. The way we read the legislation, and again, I said there are no regulations from the Internal Revenue Service on this yet, is that these 3 changes are voluntary. You can still design your plan in the way in which you want to. We think for most employers, it's probably going to be a good idea to go along with the changes in the legislation. It's going to make it a little bit less painful on participants. It's going to allow them to continue to participate even though they may have an immediate cash crunch, so they can start to rebuild their retirement nest egg without that 6-month suspension. And administratively, some of the other things are a little bit easier to handle. So we think most plans will probably adopt these provisions. And our approach is that's the best practice. We're going to certainly talk to our clients about that.
Yeah. Well, so, Michael, I've got a question for you and for the rest of the panel as well here. Interestingly enough, even over the lunch hour here, I actually got a question from one of my clients who was talking specifically about the hardship distribution changes and asking about timing for doing amendments to the plan. Have you guys heard anything from your clients? Are they are they more comfortable making the amendment ahead of time, sort of at this point going in? Are they, because there are some issues here that I think we might talk about things like the fact, like say someone who takes a hardship in November, do we stop their 6-month window come January? Because there are some issues that maybe we'll get some clarification on. Are you advising the people you guys talk to wait?
Well, the interesting thing about these changes in the law, they become effective on the first day of the plan year that begins in 2019. For a calendar year plan, that's 1/1/19, but if you're on a fiscal year, it actually will come into effect as of the first day of the plan year. The second thing to keep in mind is as we read this at this point in time, you can actually adopt the amendment at any time before the last day of the plan year to which it applies, so you can do it retroactively. So by 12/31/2019, you can adopt the amendment. The problem with that is you have to operate the plan consistent with whatever the decisions are that you're going to make that will be incorporated into that amendment. So we don't like doing that. We usually think that if you're going to make the decisions, let's do the amendment in advance so that the document and the operations will match. We don't like the fact that operations may precede that amendment. So I think a best practice is as soon as you can settle on the options that you may want to select, then do the amendment at that point in time. The interesting thing is if you don't like that, you can always change it prospectively and change some of these things prospectively and do some things other than that. The issue with respect to whether or not, if somebody takes a hardship in the latter part of this year and their 6-month suspension runs sometime into next year, that's a little bit more difficult to answer. I'm going to ask Jamie to kind of chime in and talk a little bit about our past experience when changes like this occurred and where we seem to think clients should go.
Yeah, thanks, Michael. When the hardships changed in the past from a 12-month suspension period to 6 months, a lot of record keepers kept the 12-month suspension period for anyone who had taken a hardship prior to the effective date of that change. And that seems to be the way that we're leaning in our record keeping system because of the way it has already been programmed to automatically take that suspension off after 6 months. It's not to say that a plan sponsor who has participants in that boat and would like to see them to defer might not be able to change that and manually update that record keeping system. But I think for the most part, suspensions prior will remain, and this will just be a prospective change going forward. It's interesting to note we do prefer to have the amendment done ahead of time, but we are still waiting on our document providers to prepare that language because they've been waiting as long as they can to see if the IRS has come out with guidance. Mm-hmm. I do believe they're anticipating getting it done before the end of this year.
That was going to be my next question. You expect that they'll probably come out with a sample amendment before
even if they don't.
Even if it needs subsequent tweaking or adjusting.
Yeah, and I think what they're anticipating to do, a lot of these changes are not exactly the same, but are consistent with kind of the way they were changed a few years ago, is using similar language in hopes that the IRS guidance would follow that same logic.
And just to add to that rather quickly, we are anticipating creating a model amendment with what we consider to be the best practices approach, and that we will adopt that as the document provider en masse and sign it, provide it to our clients. We use a volume submitter, so the IRS allows us to do that, but then we will offer to our clients who want different options the ability to have a custom amendment to tweak it whichever way they want to do, because these have some variations and different clients may want different things with respect to them.
Okay.
With that, I believe we have a few questions that came in. So Don, if you could read the questions that came in.
We do have two questions that came in. One was asking about the suspension period, and we've just discussed that. The other question is centered on, are in-service distributions impacted by this regulatory change?
It's a good question. Other than the hardships, I don't think there have been any other changes with respect to in-service distribution. So if you've got for example, an in-service distribution at age 59 and a half, that's something that will still continue. There are no changes with respect to it. So the only legislative change impacts are with respect to these hardships, which in many ways will make it a little easier.
Yeah, I think Michael, that's right. I think the law was specifically addressing that particular area, type of distribution in this case.
Good. Okay. That's the only questions that we have in this section.
Right. Okay.
There is an additional thing that had to do with respect to use of retirement plans in the California wildfire situation of the last year or so. It's kind of highly technical, and we haven't seen much interest in it, so we're really not going to talk about it. If you have any questions, certainly send them in to us, and we'll address them.
Okay, thank you, Michael. Now what we'd like to do is touch base on a couple of the items that have gotten a little bit of press, some rulings from the IRS. So with that, Michael, I'm going to turn it over to you.
Yeah, I think we're going to concentrate on the two middle ones just because that seems to be where there's a lot of interest. The IRS did actually change a rule with respect to the use of forfeitures and allows their use in funding qualified non-elective or QNET contributions or qualified matching contributions, QMAC. It used to be that the IRS said that you could not use money that was not fully vested at the time it was contributed to the plan for those purposes. So if you had to do a corrective contribution of some sort, or you failed a test and needed to fund that, you had to actually write a check and make another contribution, even though you had forfeitures available for it. Obviously, forfeitures were not fully vested when they were contributed to the plan, or they never would have been forfeited. The IRS has now said, now, as long as they're fully vested at the time you allocate them, then you can use forfeitures for QNEX, QMAX, and those kinds of things. That's actually something the industry was trying to get done for a number of years. It's a good use of forfeitures. So you may want to consider how you use forfeitures or what your plan allows, and take advantage of this if that's something that might be of use to you. I know there are some issues with respect to the plan language. So, well,
that's right. And in some plans, well, because of this rule, they followed what the IRS and Department of Treasury said, that you couldn't allocate them to offset. You couldn't allocate forfeitures to offset safe harbor, QNEX, QMAX, because of this rather oddball language out there, which again, thank goodness has now been corrected. It did cause some problems. I know we heard stories and seen things where a plan switched from a vesting schedule to a safe harbor schedule, and all of a sudden they've got forfeitures and they've got nothing to do with them because the only contribution type left is a safe harbor contribution. So it is a nice cleanup, and really that's what it is. As far as plan language goes, right, I've worked with the volume submitters and prototypes from time to time, and a lot of them were drafted with the original IRS position in mind, but it seems they're coming around. I think when we were talking ahead of time, you indicated that one of the documents you worked with included language that was designed to be flexible to incorporate this kind of change, whereas other ones might need an interim amendment, which is something that I think the TPAs will typically provide to their clients as part of the service.
Yeah, our volume submitter documents did have the language in it that restricted the use of forfeitures when they were drafted for PPA, but also contained some fallback language that said, this is the rule unless the IRS gives us additional guidance, which they did. And they actually gave it earlier this year or late last year in proposed form, and said you can go ahead and follow this. And when it's finalized, you know, if we change anything, that's okay. They really didn't change anything when they finalized it. So we had actually gone ahead and done an amendment to the plan just to clarify that language. We didn't feel the amendment was absolutely necessary, but just to remove any question as to whether or not it was, we did those kind of overarching sponsor of the document amendments, and I think quite a few people did that and kind of switched back. So, but we did have to educate plan sponsors. You know, we had done a lot of education right before with the signing of the TPA restatement that you couldn't use the forfeitures, and now backtracking to say,
now you can.
now you can.
Now you can with your documents.
Right.
With respect to any plan documents necessary to review your plan document and make sure there's no restriction.
Yeah, good point, Dave. You've got to follow the terms of your plan. Even though the IRS has made this a little more flexible, you got to make sure your plan allows it and amend if necessary to get there. So
right.
The other thing we want to talk a little bit about, and there's been a lot of trade press about student loans and kind of coordinating a student loan repayment program with a 401k plan or other retirement plan. And this is part of a situation that is created where a lot of employers are trying to recruit and hire people, and a lot of those people actually have a lot of student loan debt, which seems to be a little bit of a national crisis at this point in time. And what they want to do is they want to encourage the employees with that student debt to continue to pay their student loans off, but not necessarily to penalize them because then they can't participate in the retirement plan. So what had happened and what got this a lot of press is that I'm going to mention the name of the company because it's fairly well known as Abbott Labs, giant pharmaceutical company, actually wanted to do this and create a situation where as long as the employee participants were paying a certain amount against their student loans and not necessarily deferring into the plan, Abbott would actually make a non-elective contribution into the plan that would be in an amount equal to the maximum match these people could have gotten had they participated in the plan. Kind of a novel approach. So it's a non-elective, but only for certain people who are actually paying their student loans. And then the IRS kind of got involved because Abbott Labs asked for a private letter ruling, a PLR as we call it, on a very technical issue. And that technical issue was called the contingent benefit rule, which says you cannot make contributions into the retirement plan contingent upon something happening outside the retirement plan. So the issue of a participant or an employee paying student loans is external to the retirement plan, but it's still going to trigger this contribution into the plan. The way Abbott did it was it is strictly voluntary. People can flip-flop between the student loan program and deferring and get the match. The match or the non-elective they would get if they're paying their student loans exactly match the maximum amount of the match they would have gotten if they deferred. And the IRS ruled in that highly specific fact-based scenario that that was not a violation of the contingent benefit rule. I go into the weeds on that one a little bit because a lot of people are simply saying the PLR authorizes this, and the PLR does not authorize this. The PLR actually looked at that highly technical issue and then said, okay, Abbott, you can go do this, but you still have to comply with all the other rules that apply to contributions like this. And we see a couple of things that are at issue. The most important of which are there are some testing issues. When you're giving some people a contribution and not others, you have a potential testing issue. It really didn't impact Abbott Labs because they have about 99,000 employees or so. So if they give this benefit to a couple hundred or 1,000 or two, it's rounding error on their test. It's not going to impact their tests. But for smaller companies and other kinds of companies, it may have a bigger impact. And especially if you're giving this benefit to somebody who may actually be a highly compensated employee, that's of course going to create some additional testing problems. So I'm going to ask Jamie to talk just a little bit about some of the issues that we're looking at or addressing so that this kind of thing can become a little bit more widely available and not just for the 99,000 employee company. So tell us a little bit about some of the testing issues we're seeing.
Thanks, Michael. Yeah, we have been looking at it at One America to determine kind of some best practices around it, what potentially the best way to design a plan like this for a little bit smaller employers than Abbott Labs. So we've taken some of our plans that we feel may fall into that category, that roughly over 1,000 participants, taking some industry knowledge about what the percentage of incoming workers have student loan debt, to try to run some what we call proactive tests, or just looking at to see whether these plans would actually pass testing if they offered a program like this. And we're still in the works of that because we're working through the actual kinds of tests, or which tests would need to be run. As Michael addressed, the private letter ruling mentioned testing would need to be done, but really didn't talk about, in depth what that would be. As to whether or not this is an allocation condition placed on those non-elective contributions, which causes it to be a coverage issue and a coverage test item, or whether it's everyone's eligible for it. It's just if you don't receive it because you don't make the loan payment, you have a 0% contribution. You're now looking at more of a general test for the actual allocations, and some people are receiving it and some people are not. So it will highly depend on the breakdown between your highly compensated and your non-highly compensated individuals. And we kind of feel, or the feeling is, we don't really know, but the feeling is the companies that will want to do this are hiring technical people that at the time they hire them probably are non-highly compensated individuals, but likely in a year, 2 years before they pay off their student loans, will become highly compensated individuals, and so may flip the testing results. So it's something that would need to be watched in the plan to make sure that even if it does pass 1 year, that it's not going to flip the next year to be.
Right, and thank you, Jimmy. I think that's right. It's the groups that are going to have very often have some of the biggest debts are the people going into professional organizations, whether it's lawyers or doctors or accountants or engineers, and which is just the kind of demographic that's the hardest to work with, because it's a small group of people who can be fairly highly compensated. I suppose you get into, in some of your testing, even looking at like top paid group testing, whether there's an option, sort of, tips and tricks in playing games with testing, as I'm sure you guys deal with at One America on a daily basis. How can you get through the hoop to get there? And, is there some way by doing some of those factors? And so it sounds to me like whether this is going to work for a particular organization is going to be one by one analysis, kind of iterative, trying out different things. To see if it gets you there. So good. Shelley or Michael or Jamie?
Yeah, what I'd like to do is just have Michael and Jamie comment. I think there's been, some misinformation after this private letter ruling came out with, as it was just explained right now. I think there's maybe some misinformation as far as how it's being applied. So I think, Michael, you had some insight to that. If you
we certainly are looking at what's going on in the industry and what other providers are doing, and we are aware that another service provider out there does it a different way. And the approach that they're taking is that the employees who are paying down student loans can get, essentially a matching contribution, and they're calling it a matching contribution that will either go into the plan or actually go to pay down their student loans. So they're doing it in a way in which you can either pay your student loans and get a contribution, or you can actually contribute to the plan and then have your matching contribution used to pay your student loans. We don't think that that's necessarily a viable option. I think it exacerbates some of the testing problems, and part of it is terminology. Because when you say they get a matching contribution that will be used for their student loan, I'm not sure that's actually what's happening. I will tell you that even some of the press with respect to Abbott Labs refers to the 5% non-elective contribution as a match. A match on paying your student loans.
They're getting a little fast and loose with the terminology, Michael.
Yeah, you have to be very cautious because a match is different and it has different allocation requirements. It has different testing requirements. But that's what some of the popular press had called it. You're matching your student loan payment. And in a sense, that may be true. But in terms of the retirement plan, it's a non-elective contribution. And so we want to make sure that when you look at this, you're using the right terminology and making sure that it's structured in such a way that you avoid some of those problems. The situation where if a match is either going into the plan because you defer, or a match goes into paying your student loan debt, that is probably a case where that is not actually what's happening. So be cautious when you read these things in the popular press. And we're keeping an eye on it to see what's going on in the industry, obviously, to develop our own best practices for our clients. So,
Michael, did Abbott make the match, for lack of a better term, subject to a vesting schedule?
I don't know, and I don't know that we've seen anything with respect to it. I think you probably could, but you're also adding a layer of complexity to it. I don't know if they have a vesting schedule attached to the match, the real match into the plan. I would think that the reasons they would have a vesting schedule for the match may be the same reasons that they want a vesting schedule on that non-elective, but that's going to complicate life to a great extent. I'll let you in on a little industry secret in that there are limits to the number of different vesting schedules you can have on any modern record-keeping platform, and you don't want to confuse participants, and you don't want to confuse HR and benefits people either. So if there is a match on it, keep it simple, keep it consistent with everything else. We consider it a non-elective, and in the common parlance, that's a profit-sharing contribution in most cases. So if you have a vesting schedule on your profit-sharing contributions, this is probably going to go into the same bucket. It will be subject to the same vesting schedule. What Abbott's doing, I'm really not sure, to be honest with you.
Thanks.
Okay. With that, we are going to take a little bit of time and talk about plan administration, because that does tie into some of the things that the panel will discuss with respect to Department of Labor and IRS audits. So what I would like to do is start with Mike and talk a little bit about, from the standpoint, certain plan features as far as, ways that a document would be constructed, and then we'll have Michael and Jamie kind of weigh in from the practical side of the actual record keeping of that. So, Mike.
Oh, great. Thank you, Shelley. So yeah, our first topic is talking a little bit about an employee description, participating participant description that gets to be problematic for a lot of employers. You'll see we've got part-timers, temporary and leased employees listed up here as potentially excludable classes. The struggle that I think a lot of plan sponsors have is they want to exclude these people because they're not regularly expected to be around for long periods of time. If they make contributions, the small account balances, they just get to be kind of difficult to deal with. So, and plan sponsors want the plans to be a reward for good and long-term and true committed service. So they'll say, yeah, can we exclude our part-timers? Can we exclude our seasonal employees? The IRS has said, well, they look at that and say, if the only real distinction between who you're excluding and who you're not is the number of hours that they're expected to work, that's not an exclusion that you can get through by saying we cover enough people. The IRS looks at that on a person-by-person basis and said, if employee X is working the requirements they need to get in the plan, that person needs to be let in. And if they otherwise are the same as all your other employees who are in the class of employees that are eligible to participate, that's a problem from the IRS's perspective. Some plans are set up, and I think we refer to them as dual eligibility type plans, where people who are expected to be full-time will be allowed in immediately or nearly immediately, and people who are expected to be part-time, we keep them out for a year, or up for 1,000 hours in 12 months before they get in the plan. I think we see that a lot. I guess we'll ask Michael and Jamie to comment if that's a frequent structure you guys have seen on that. But otherwise, how do you help employers draw the line? Because they do want to exclude certain classes, and that line seems to be a little blurred to things like interns. Interns are people who are going to be there for a temporary period of time. Is that a sufficient difference? What kind of counseling do you give your employers to help?
Yeah, we do see the dual eligibility status quite often, where and what we normally hear is those part-time, seasonal, temporary, whatever you want to call them, don't receive other benefits, so they shouldn't be allowed in the plan. That's kind of what we hear from plan sponsors. And so setting up this dual eligibility keeps them out at least as long as the minimum standards that the IRS lets you keep them out. So if they work 1,000 hours, they're gonna be coming in. As far as other classifications that might be tied to hours, it's a fine line that you walk. So we often counsel plan sponsors when they bring this up, asking more questions about how do you define your intern population? What is your definition of intern? Does it solely relate to the number of hours they work or how long they're going to work? Or is it more tied to the fact that they're in a college degree program and they need this experience? So we recommend that when you add that classification of employees, that you have something in your HR documents which defines that term and lets us know, that it's not tied to hours. We would prefer it's not tied to hours in any way, but if it is tied to hours in some way, that's not the main point of that classification, that there's something else behind it that gives that classification an actual.
So the more you can put in your file that would say this person, this is what makes this person not effectively a part-timer. What besides the number of hours they work makes them different than everybody else? They're a student who's going back to school in the fall, things like that. Those, I mean, my inclination is those all help your situation and your defending of it. That's kind of the way you guys would tend to lean to that.
Yeah, I think you have to be very careful. I mean, if you've got a good, solid basis for the exclusion that is not directly related to the hours worked, you're going to be in a better situation. So create the classification appropriately. Make sure it applies only to those specific groups, but also make sure you understand exactly what your plan document says. And the bullet point we've got up here says part-time, temporary, and leased employees. Those terms are often confused, and they sometimes are used interchangeably. They are not. Leased employees is a highly technical definition, and your plan document, I'm sure, spells it out whether you include leased employees or not. And we see a lot of situations where when you get into the leased employee situation, especially for somebody that you keep for a relatively extended period of time, then maybe you have to include them in the plan. Maybe you want to include them in the plan, and maybe you don't want to include them, and you've got to be very cautious as to how you define that. And it's different than temporary or part-time workers or seasonal workers or whatever the classification is.
And I think it's worth mentioning. I know we have a question in a second here. Just the comment on temporary. Temporary is a funny term too, right? Because different people. This is the classic example of make sure you understand what your plan means, interpret it, and remember to apply it consistently. Some people consider, when you said temporary, would say, oh, that means we're hiring someone from a temp agency. Some would think that means someone who's expected to stay on the job for 3 months or less. It's important to understand what your plan means. And in terms like temporary, it's fair to interpret it either way, but you got to stick with it once you make the interpretation and make it clear to your employees. That's your best defense and challenge on
Well, and I'll tell you, a lot of employers do this. One America does this, as a matter of fact. We call it temp to hire.
Yeah.
So they're a temporary employer because we get them through a temp agency for 3 months, and then we like them, they may become full-time employees. That creates all sorts of interesting issues with respect to what's their service start date. When do they get credit for whatever they're doing? And leased employees, you have the same issue because the definition of a leased employee is somebody who works substantially full-time for at least a year, right? And so you don't even know that they're technically a leased employee until a year has gone by. And we've talked offline and previously about this, that if they're a leased employee and you want to hire them, it's probably because you like them and you probably want them in the plan.
So Don?
We have a question.
We do have one question, and Michael, you probably want to answer this one. If we include part-time temporary employees to participate in the plan, can we permit them to contribute to the plan but not be eligible for any company contribution matches?
Well, you certainly can include them in the plan. We'll start with that. Can you exclude them from other employer contributions? You really come back to the same issue of, you could exclude them provided that the exclusion of that person isn't effectively a bogey for we're excluding them because we don't expect they're going to work a certain number of hours. It comes back to the same distinction. So I don't know, Jamie or Michael, do you want to add some color there?
Yeah, I mean, I think that we would see the same thing. You could have a dual eligibility where the deferrals, you let them in, immediately, just like everybody else, so they can defer. And you could have a dual eligibility on your match. impact coverage testing, in which case we may be able to segregate the populations there between people who have completed a year of service and worked 1,000 hours and those who haven't, which sometimes makes that test easier to pass. We see a lot of employers also, maybe they allow them to become eligible for the match, but they have allocation conditions on their match of 1,000 hours. So in every plan year, you have to work 1,000 hours in order to receive that match, which will effectively keep these people out in any plan year that they don't work those 1,000 hours. That can again impact coverage. So it's just important to note that if you have a lot of those employees, letting them in and then keeping them out based on allocation conditions could actually be detrimental to you.
Oh, okay. So I guess we'll move on to our next bullet point here then. Shelley, are we ready to move on?
Just a quick comment with respect to, because again, everything with eligibility then kind of ties to some of the failures we see in plans really can be enrollment, which would be just effectively say voluntary enrollment versus automatic enrollment.
So let's talk about that for just 1 minute before we move on. And this is partly a question to our friends from One America here, to Michael and Jamie. What do you do, right? Because employers, and when an employer comes to you, and I'm happy to say what I would tell them too, when an employer comes to you and says one of two things: we missed this person, they should have been in the plan, they weren't, or we let them in too early. I think in some cases we have easier solutions than others. It seems to me, if I'm the IRS, and I don't know that based on our attendance list of any IRS agents on the phone, if you are welcome, but if you're the IRS, how upset do you get about someone being let in a little early? Do you let someone kind of say, hey, we're going to amend the plan, to allow this, and we're kind of move on, or do we say we really want to kick them back out?
Yeah, good questions. The interesting thing is about both those scenarios is that the rules on how you fix it are relatively straightforward. If you let somebody in early, and assuming they're not a highly compensated employee, because that changes everything.
But it's hard to let someone in early who would be highly compensated until they're a year in, right?
Well, that's true. There are ways that it does in fact happen. But if you let somebody in early, you've got two options. You can either amend the plan to allow them to remain in the plan, and we've actually seen that where you actually name the names of people who have been let in early, or you can kick them out, which means you have to take the money back out, you have to adjust it for earnings, you have to give it back to them through payroll, basically, if it were salary deferrals. So fairly straightforward. It's always hard to take somebody out of the plan. I'll tell you, it actually happened to me once where an employer let me in the plan early, and I really said the easiest option is to amend the plan and put my name in it saying I could continue to participate. They didn't, so they had to give me the money back. But then the other situation is where you don't include them. Again, the rules are pretty clear on that, and you have to make a contribution. And Jamie, you want to talk a little bit about the corrections for not including somebody in the plan when they should have been included in the plan?
Sure, thanks. Usually it involves making an employer contribution, what we call a QNEC, qualified non-elective contribution, anywhere from 50% down to zero. Based on recent IRS guidance, they've kind of liberalized that a little bit so that if you catch it early enough, you can actually not have to make that QNEC contribution to that employee. You always have to make any matching contributions that employee would have received.
100% of what they would have received.
Yes, 100% of what they would have received had you actually let them in the plan. And there are any number of ways that you determine what their deferral percentage would have been based on the plan design, whether it's safe harbor or not, and that sort of thing. And that's outlined in the IRS's program. It can get pretty costly, especially when we're talking about these part-time individuals that if you haven't read your plan document and don't understand that it doesn't have dual eligibility, doesn't exclude these part-time individuals, and you've kept them out of the plan, and then you realize it and it's gone on for years, it can get costly pretty quickly, and likely a lot of those part-time individuals are no longer employed with you, so we have to go back and find payroll records, try to locate them now, their addresses. We have to figure out if they are vested at all in any employer contributions we make. So, how many hours did they work every year that they worked? While the contribution itself can be painful because somebody has to write a check to the plan. Once you do that, there is a lot of administrative work that comes along with it that people don't anticipate when you say, oh, you have to make a contribution to plan.
Okay, well, I'm going to take this, I'm going to push this one step further here, because again, I'm always interested in the TPA's point of view here as a private practice attorney. And again, I will share my comments too if you'd like to hear them. So the IRS gives these great pre-approved corrections, as we talked about. How do you feel about things that are, in air quotes, fair, but don't quite meet the IRS? This is a general theme, by the way, of any of the IRS correction, right? The IRS correction method says, essentially, I think says, the corrections we give you are deemed to comply. But I've always kind of read it as there's a little room for a little bit of creativity there. So let me get, something that doesn't perfectly fit one of those corrections. Do you guys feel comfortable getting a little creative? What do you look for from a client who says, gee, the person still has a whole bunch of money and a whole bunch of time to contribute. Yeah, they don't quite fit what the IRS does. What do you do with that?
Well, it's always the client's call.
Okay.
The only thing we can do is to educate and inform them. We will, typically not recommend something other than what we know is going to work, because the IRS has in fact said this will comply. So if you do it this way, you don't have any worries. Mm-hmm. I think part of that is the value of being a non-discretionary directed service provider. But we do have clients that will want to push the envelope. But I think if you want to do that, a couple of things to consider. One is make sure you're seeking your own counsel's advice. We will say call your ERISA attorney and talk to them, because there is a risk involved here, and the risk is if the plan is unlucky enough to be audited, the IRS will not approve the correction. And I will tell you right now that the number one reason that DOL gets involved in audits is participant complaints. So if you do something that a participant isn't happy about, they may call the IRS or the DOL and register a complaint, and then we'll see where that goes. The other thing is that you still have to be cognizant of what the plan says and how the plan is going to allocate a contribution. And it has to have the appropriate language in there to allocate whatever your corrective contribution is, and if it's not one of the standard ones, your plan document may not already contain that language. You also have to be cognizant of the downstream impacts, because if you're doing something other than these rules, it may not be deemed a corrective contribution, it just may be deemed to be a contribution, and now you've got a discrimination testing issue and a variety of other things that you may not have if it were one of the approved ones. So there are downstream impacts, and there's a lot to discuss with your counsel. I don't know how you quantify that risk.
Michael, have you had clients that have had the IRS audit, the IRS comes in and they identify previously unknown situations where you use the wrong definition of compensation, you let some people in early, and if so, what has the IRS recommended, or I guess more importantly, required as a method of correction?
Yeah, I'll tell you right now that using the improper definition of compensation is the number one error that the IRS deals with in terms of VCP filings or corrective.
And I bet the number one error that you deal with.
It's probably the number
one of the number ones we deal with.
Yeah, we joke about it that, if somebody can find a plan that doesn't have a compensation glitch, that they get a free dinner or something. But it's a complicated issue. Yeah. Because there are multiple definitions of compensation. There are safe harbor definitions, there are safe harbor modifications to the safe harbor definitions, and compensation can be defined differently for different purposes within the plan. And you have to make sure that you define that in your plan document and you administer it completely. And yeah, the IRS will find some of those things. We actually are now seeing some more of the auditors, the annual audit for large filers are coming up with better testing methods to see compensation kinds of issues. And part of that is because they're also under the spotlight from the DOL to do better audits. So we're seeing a lot more of those things. The corrections can be somewhat varied. You can either go back and redo everything that the plan did with that definition of compensation, do it correctly. Sometimes that may mean taking money away from people who got too much, and sometimes it means giving contributions to people who got too little. And that can be an extremely complicated and costly process because your service provider is probably going to charge you by the hour to redo all of that stuff. Sometimes you can actually go back and do a voluntary compliance program filing under the IRS program to seek a retroactive amendment to correct the document to match that which you were actually using. I will tell you right now that our experience in doing that has been a little mixed. The IRS requires, and they'll use this term, clear and convincing evidence that the participants knew what to expect operationally. So if your plan document says your compensation is A, but you were using B, they'll want to make you produce everything that the employees ever received in communications, they'll, educational meetings, to show that you actually told them comp definition B is what you were going to use and that they got what they were expecting. That's not easy to do, and I will tell you, most documents now are produced via document production system, so if you put something into the plan that says you're using comp A, your summary plan description is driven directly from the plan document. It'll say the same thing. Some of your regulatory notices will say the same thing. So to prove clear and convincing evidence that the employees knew what to do is getting a little bit harder. And I'll be honest with you, we've actually talked to the IRS and said, look, nobody reads the SPD, nobody reads the regulatory notices.
No reliance, right?
Just look at the glossy educational materials that say what we wanted to say, and they'll say, no, SPD it's an important document, and we presume everybody reads it line by line.
When in fact, it's only produced when litigation is pending. Were you going to say something, Dave?
No.
Oh, no, so Michael, I've got, and Jamie, I've got a question or two follow up on that. So the very first one, well, actually, we'll wait on Scrivener's error. I'm always kind of interested. It's a term that attorneys like to throw around to describing these things. I know the IRS is generally pretty anti-use of the term Scrivener's error. I suspect private practice attorneys, Dave, you're welcome to weigh in on this as well if you want. We're a little more aggressive, but understanding that if the IRS looks at something and we say the document simply didn't reflect the intent and we can show you all these things, that may not be enough. And so, I mean, the safer route is clearly then to go into the IRS and maybe do that anonymously, right?
Yeah, I will tell you, the IRS, since you uttered the word, I'm going to respond.
The S word?
The S word, Scrivener's error. Scrivener's error is, document drafting. A Scrivener is the person who drafts the document. So Scrivener's error is an error in drafting the document. The IRS does not even recognize that the word exists. We had a VCP filing that we did where we claimed that there was a Scrivener's error, and we showed all the documentation to indicate the intent of the plan sponsor and everything. And the word Scrivener probably appeared 18 times throughout the entire VCP filing. And one of the things that they made us change was they made us remove that word from our own filing, saying there is no such thing, so you can't use it, so take it out. But then we still had to jump through the hoops on the clear and convincing evidence with respect to what the employees had said.
Even after you took out the magic words.
Right, even after
the forbidden words.
We did in fact do that anonymously because the situation was a little touchy. And it involved not a compensation issue, but what we talked about just previously, there were a certain group of people were erroneously excluded. And this was an auto contribution arrangement, so I know I'm going back just a little bit, but you've got to make sure you understand how the features of the plan work, whether it's an auto contribution arrangement, whether it's enrollment issues, whether it's compensation. Because then if your only remedy is a retroactive amendment from the IRS, that is, I wouldn't call it a crapshoot, because I think if you get your ducks in a row and you do it the right way, you can persuade the IRS that they will allow you to do that. Fortunately for the situation I just described, they did, with a little hair raising at times when they wanted us to remove the word Scrivener. It's like,
Yeah.
But there is risk involved.
Yeah, well, I mean, even on the point you make, by the way, is well taken, that the way the software works on these things, you make one mistake or not even making a mistake on the part of a TPA, but on just a misunderstanding, whatever it is, and suddenly it appears everywhere. I would probably throw that in front of the IRS and say, "Come on, IRS, you know the system." But it sounds like you even got some resistance on that when you've done that approach.
Absolutely.
Yeah. Let me ask one last question on compensation. Yeah, because this is another thing that I see in my practice that's a practicality problem, and that's non-cash comp. Right. So this is your taxable group life and all that. What do you do, right? So it's easy enough to do a profit sharing contribution because by the time you get to January, February, you know the total amount you're going to be putting on the W-2. So you get to January, February, there's no cash left to do a deferral on your group term life. Do you find that do you recommend to your clients that they use compensation definitions that exclude these? How does a client deal with that in the real world?
We did try to address this in our volume submitter plan document, where we have included in our basic plan document kind of a catch-all that says for non-cash compensation that the plan sponsor can actually have their own administrative procedure about whether or not they're going to allow deferrals off of that. So while the definition of compensation in the plan document likely includes that information because it's got to be reported on the W-2, but they're not actually receiving cash for it, they can have that procedure that says, hey, we're not making deferrals off of that. We're strictly taking your cash. So we tried to address that. Again, this all comes back to documentation that employers have and that it's best to document kind of all of your policies and what you're actually doing. And I think to what Michael pointed out is, and we've been talking about, there could be mistakes in the plan document or not even mistakes, but just misunderstandings. Is your plan document actually governs how the plan should be run, not what your operation is doing, not the flip side. The operation doesn't govern what the plan document says.
In particular, payroll.
And in particular, payroll, and we hear that all the time as our plan sponsors say, well, our payroll company set it up that way to include or exclude a certain item of compensation. But in reality, your plan document needs to be taken to your payroll provider and they need to set up payroll matching the way your plan document is designed, including or excluding things. Same goes for automatic enrollment, is knowing if you're going to be adding it to your plan, really talking with your service provider about what documentation you're going to be receiving, what your responsibilities are in identifying which participants should be enrolled, initially when you put it in, and that sort of thing. And I think that goes for a lot of administration, but those are two touchy subjects. I think that happens a lot that, plan sponsors may think other people are doing this. My payroll provider handles compensation, so I don't need to worry about it. And my service provider has handled automatic enrollment, but in reality, that might not be the case.
Thanks, Jamie. We've listed some other things that we typically have seen in the administration that will come up when a plan is audited by the IRS or the DOL. With regard to distributions, we are going to talk about that under the audit and investigation section. So we are going to move on just in the interest of time. We did include on the next slide just some additional items, the employer allocation conditions, which I think Jamie touched upon. Again, investment funds changes, just making sure that you administer those correctly. Michael, do you want to add just a comment with regard to the F-curves before we move on?
Yeah, employee plans compliance resolutions service system. We argue about what the S stands for a little bit.
I bet you do.
F-curves, as Shelley said, is what we call it. That is the program under which the voluntary compliance or VCP filings are authorized. There's also self-correction for certain things that you can, if you comply with their requirements, you can do self-corrections. Just when we say self-corrections, I'll just let you know that that's not just do it. It's do it and document it, because documenting what you did from a self-correction perspective is a requirement of self-corrections. We call it a self-correction memorandum, if you will. So if you're going to do that, and only certain things can be self-corrected, you need to do it. The thing about a VCP filing, though, I want to mention is that it is not a fun thing to do. It is lengthy preparation. You have to gather all the information. It's part art and part science, because you have to draft an application using certain format and certain types of schedules that the IRS mandates. You have to actually present your best case scenario and try to do so persuasively. And I will add that the person who signs it under penalties of perjury that they are telling the truth, and that they are disclosing all of the known issues with respect to the plan. So you can't really technically file a VCP for just one issue when you've got 6 others. So you've got to do your due diligence, you've got to gather all the information, and you correct everything all at once. And then you sit back and wait. And it takes a long time to get a response from the IRS, and clients are not always patient because it can take 6 months. We've actually had one that went almost 18 months before we got a response from the IRS. And we have a saying around the office, don't poke the bear.
Yes.
So you do not call the IRS and say, why the heck haven't you gotten to my VCP filing? Because they will, and then you won't like it.
Well,
so don't poke the bear. It'll take a year to 2 to finally get something resolved through VCP from start to finish.
And you are dealing with real people at the IRS, right? My experience as recently as like the last week or so, again, they will want different things, and they'll want certain different things excluded. And sometimes it's not exactly what the EPCRS says is how it's supposed to do. But you play nice in the sandbox to continue on the whatever buzzwords of dealing with the government and the audit system and all that, which is what we're kind of segueing to gradually here. You kind of try to find a way to get where you need to get, and what can you live with. So there's a negotiation that goes on with them in a lot of these. The Department of Labor doesn't like to negotiate. The IRS seems to like to negotiate, and they on this one we have rewritten our attachments 2 or 3 times because they said, well, in one case you can't include attachments that include the plan documents. Okay, we thought we had to, but that's fine. That's how you'd like us to do it. We'll do it that way. So, okay. So
I will just add to that.
Yeah, please.
If they tell you to remove the Scrivener's error from the document, remove it. Those things you don't.
What hill do you want to die on? The kind of thing.
But they will, if you've got a plausible argument, be reasonable and listen to it. Your goal in filing the VCP is to get to the point where you can negotiate and not have them pull the trigger and deny it before you've had that opportunity. So play along and do what they ask so you can get to the point where we can have a real discussion about it.
Okay, thanks, Michael. We didn't include a slide specific to corporate transactions because a lot of the items that you have been discussing as far as operational, a lot of these will come up when a client is doing due diligence because of an acquisition. So, David, you want to add some commentary around that?
I'm curious what you have seen. Going way back, our advice to clients was generally, to the extent you're buying another company, don't take the plan. Any problems with that plan are going to come over with that plan, and you're probably going to want to merge it into your plan. So if it was an asset deal, leave it behind. If it was a stock deal, require language in the purchase agreement saying that they will terminate the plan immediately prior to closing and provide distributions. More recently, it seems like clients are more willing to take over those plans. And there's a recognition that there's a disruption with the employees in the event that you have to shut down a plan and tell them that there's going to be a period of time before they can come into the acquirer's plan. So I'm curious if you have seen the same thing, which is a move towards taking over the plan.
Mergers and acquisitions are always interesting because there's a fear that the plan is an unknown and that it's nothing but a liability. But the truth of the matter is it's also an asset because it is, basically the retirement vehicle for the employees you are acquiring. And if you terminate, as part of the deal, you make the seller terminate the plan and distribute assets, I can tell you that 80% of those assets will be spent. So not that much.
No, that's right. That's my experience as well. The leakage, right?
Leakage.
The word the government likes to use.
So here's the thing. You're now acquiring a whole bunch of employees that you don't know that are probably going to grow old with your company, who are going to increase your healthcare costs because they go up as your employee ages, and they're not going to have the funds to retire to get them off the payroll and get them to a better place. So you're stuck. You're stuck with them. So it's an asset. I'm not kidding. And there are some studies to indicate that this is a problem, that you really do want a retirement plan that gets some of these people to that.
It gives them a plan in retirement.
Yeah. Otherwise, you've got 70-year-olds still working that are maybe still getting healthcare benefits from your company, and that's an expensive proposition. And all the other things, and I don't mean to pick on old people because I'm one of them. They're less productive. They may not be as adept at some of the newer technologies. I mean, there are a lot of reasons why you want them to actually have a good retirement and make it available to them. So personally, I think looking at the plan as an asset and balancing the liabilities is a better approach to go. And this is probably a plug for you guys in that there really isn't that much in a plan that can't be fixed. The only question is what's the cost and who's going to bear it? So do your due diligence, get your service provider involved in helping with the due diligence, because we will look at it from that operational perspective where things are where the data may be not right or where we need to change some record keeping things and look at it. Get the right people involved, sign confidentiality agreements if you have to, and we'll do that when needed. And then negotiate who's going to fix it.
Well, that's an interesting point, Michael, and this may be really a question over to Dave. And you and I have talked about this over the months I've been here too. To what extent do you see in deals a holdback, an escrow, whatever that's somehow related to a potential retirement plan issue? I think you've mentioned at least one before. Is that something you've seen more commonly, or is that odd and rare?
Typically, I'll either find a relatively clean plan or something that can be fixed relatively easily. And so we make the decision that we're going to take the plan over to provide the continued benefits to the employees of the acquired entity. There have been a couple situations where there have been real problems. And in one situation, it was a stock deal. And because it was a stock deal, that we were taking the plan regardless.
You're right. You had no way of getting rid of it.
Yes, we could have terminated immediately prior to closing, but it was our company and we were going to have to deal with the distribution of assets. And in that situation, the corporate attorneys asked me to estimate what the cost of correction would be going through the EPCRS, what the additional contributions would be to correct the problem. In that situation, the acquired entity had improperly excluded a large number of employees. And so we did some back of the envelope calculations to determine what's the number. I think we increased it by 50% and said, that's going to be the holdback to take care of the issue.
Yeah. I would add to something in a former life, not where I'm at now. I work for a trustee and record keeper shop. There's no requirement, even if you acquire the plan, that you merge it in. You can freeze it and hold it so that if there's a problem.
I call it quarantining.
Well, it doesn't taint your ongoing plan. You just put the employees in the new plan, keep this one there. I worked with a company. I was working for the trustee at the time, an institutional trustee. We called it the dirty plan. And they would acquire companies all the time, and if there was something they didn't want to deal with, they'd merge it into the dirty plan. And the dirty plan just kept growing, but it was frozen, and it just didn't taint any of the ongoing
clean
plan.
So it's sort of a dumping ground for plans.
There are costs associated with that, and I wouldn't necessarily recommend that. I think you need to really look at it and say, can we fix this, and what's the best approach to fixing it? But you don't have to merge it in, and you can leave it separate until you fix it. And that way you're not going to taint your ongoing plan.
Okay.
So.
Thanks, Michael. What we'd like to do now is segue into really our final discussion, which is dealing with audits and investigations. In advance of that, though, we want to talk a little bit about really some hot buttons that, in these audits from the Department of Labor's perspective, two things that they're really looking at, as well as the IRS. So one being late deposits, and then we'll talk a little bit about fees and then get into that. So Michael, do you want to comment just briefly with regard to kind of the late deposits as far as?
Yeah. This has been a hot button for the Department of Labor for more than a decade at this point in time. They are looking at it. I think one of the things you have to look at is, a consistency in approach and making sure you're following the rules. There is an old regulation out there that says you have to deposit or segregate contributions from employer assets as soon as possible, but in no event later than the 15th business day of the month following. Forget that last part. That part. The 15th business day rule it does not exist It's still in the
right.
regulations, and it just is being ignored by everybody because you cannot wait that long. The rule is for under 100 employee plan, you've got 7 days, and I think it's 7 business days actually. Mm-hmm. So it's a little more than a week to segregate the money and get it into a plan. For larger plans, over 100 employees, large filers, basically, there is no rule. It's as soon as you can, and the IRS DOL has taken the position that if you can get your federal tax withholding deposits made within 2 to 3 days, and the rules on that are a little weird, but it's 2 to 3 days depending upon where your payroll falls in the cycle, then you ought to be able to get your salary deferrals deferred at the same time. Right. And I would add one more thing to that. The Department of Labor doesn't say if you get it within 2 to 3 days or 3 days, let's just say 3 days, that's not necessarily good enough, because if you once did it in 2 days or once did it in 1 day, you've now proven that that's as soon as possible, so they're going to hold you to that standard. I wouldn't say that they're that overly strict about it, but I would say whatever you do, pick a day that's 2 days or 3 days or whatever it is, and be consistent. If you don't, it's considered a prohibited transaction, and it's a reportable event on your 5500. And the rules on that get a little complicated. I know Mike wants to add something.
Yeah, no, I want to ask you a question.
Yeah, we'll let him do that.
Yeah, no, because I just love putting you guys on the spot, I guess. So here, and this is a very practical one, and I suspect you've seen it too, and I've certainly gotten the question. Okay, so my payroll person is new. My payroll person got sick, and it took us 5 days because they were new, they were sick, whatever. Do you have to fix that? Or do you say, we're moving on? And by the way, also, if you don't mind when you give your response, what does this mean when your auditor comes in and catches this? Because that's, in my experience, certainly recently, that's where my clients are coming and saying, gee, our auditor picked up. And it's not even the DOL, but you have to answer to your own auditor. Yeah. So what do you do with your auditor in that kind of case when it's something total? I mean, well, usually it's reasonably possible to do it soon, but for whatever reason, can you say it's not reasonably possible here?
I think that we've heard from some DOL agents that, because we've made that case, right?
Yeah.
We have one person who does this, and they were out on vacation, whatever the case may be, and they have come back with, you should have more than one person that can do that.
Too bad, so sad.
Right.
Yeah, no excuses.
And normally, in those instances, I mean, I think there are absolutely some situations where it's just not possible. I mean, everything happens, right? Our Wi-Fi goes down, and there's no way on earth to be able to do that.
A hurricane comes through, and your computers go down. They're a little flexible with respect to stuff.
Yeah, you're underwater.
Mm-hmm. So when plan sponsors call us with those kind of questions too, and we know they're an audited plan, I would normally recommend that they speak to their auditor.
Prospective, or
call them and explain the situation, get their take on it, because if they're going to consider it late, they're going to require that it be fixed before they finalize that audit. And you're going to be hard pressed to convince them otherwise if that's what they're going to call it. So that's usually kind of where we go is get that proactive discussion going with your auditor so that they're aware of it and they can help you make that determination.
And I don't know if there are any auditors on the phone that have signed up for this, but I'm going to apologize in advance. They're getting a little crazy.
But not the ones on the phone.
Not the ones on the phone, of course. Okay. They're learning. The situation is the DOL is actually auditing auditors because they're trying to enforce a better standard for auditors. And so there's a lot of pressure under auditors. And some auditors have been banned from actually doing plan audits. And that's kind of a career limiting move. So
when you're a plan auditor, yes, Michael, that is.
Need to talk to your auditor. We always think that, there are multiple parties involved in fashioning a correction, even one for late deposits. It's, hopefully us as the record keeper, it's your outside counsel and advisors, the plan sponsor, and the accountant, because they have to audit it, and what they find may determine what you do. But I also want to make very clear that the rule is you must segregate the assets from employer assets within these time frames, not necessarily that it's allocated to participant accounts and invested. That's a different issue if that takes too long, but you have to get the money away. We actually have a situation right now where we're arguing with the auditor, and we're even arguing with the DOL, because the auditor insisted that money that had been properly segregated from the employer's assets and was sent to the record keeper but held in a suspense account for about a week because of some glitches before it was allocated to participant accounts, was a late contribution. It's not a late contribution.
I've heard that argument made by the DOL as well.
Yeah. And the auditor insisted on checking the box on the 5500 saying there were late contributions. We're taking the position they weren't late. There may have been essentially a fiduciary issue in not getting the money invested correctly, and there might be an earnings adjustment there that has to be, but the prohibited transaction did not occur. And I don't know where that's going to go, but it's a technical distinction, but one that's important, and you might want to make sure that you understand where that is. And I say that in certain situations because I have recommended in the past when somehow or another you could not get the money to your record keeper, go down to your local bank and open a savings account in the name of the trust, put the money in the trust that's now effectively segregated from the employer assets. You've got an argument. Will the Department of Labor take that? I don't know. Yeah. But I think I want to talk just a little bit about it in that it is a prohibited transaction, so there is a potential that you have to file a 5330 form with the IRS. And lately what has been happening is the DOL, when you check that box in the 5500 saying you've got late contributions, they may send you a nastygram that says, you know, thank you for fessing up and thank you for correcting the problem. But according to the DOL, unless you actually go through the VFCP program, and I'm not going to tell you what that stands for because I always get it wrong, the DOL does not consider it corrected. And by the way, we think you ought to attend this nice little webinar on your fiduciary obligation so that you become a learned fiduciary. I'd like your opinion on what a client should do when they get one of those invitations from the DOL. Yeah. Our approach is when the DOL suggests you do something that is relatively painless, you might want to consider doing it.
Well, that's right. I think, right, it's only at the point where the DOL is so imposing on your ability to do your job that you start saying no. It's right. It's the pick your hill to die on kind of thing. I think, Michael, in my view too. When it gets to be too much of a problem, that's when you push back. But please, watch the video. I don't know, Bill, whatever else you're doing, I don't judge.
So that is a perfect segue into audits and investigations. So with that, I'm going to turn it over to Dave to start with the Department of Labor audit.
Thanks, Shelley. I'm going to go through this fairly quickly because I want to make sure that we have sufficient time for any questions that the audience may have regarding other topics. But you may have an investigation either by the Department of Labor or the Internal Revenue Service. And the Department of Labor, if they audit, they're going to be focused on kind of reporting, disclosure, fiduciary duties, prohibited transactions. For example, fiduciary duties, when you're selecting plan investments, is there a full and proper review considering the right factors? For your record keepers, are you going out and doing a reasonable investigation of your service providers to make sure you're getting the services at a reasonable price? One of the things that we've seen is a recommendation that you go out for an RFP on a service provider every, say, 3 to 5 years and do an investigation to see whether the fees you're paying your current service provider are reasonable compared to other alternatives. And if not, maybe consider a change. If you don't make a change, document why you're not making a change. That's what the Department of Labor is going to be looking for. Have you gone through the proper procedure with respect to your fiduciary decisions, whether it's selecting your plan funds, your plan providers, and to the extent that you made the wrong decision, that's not fatal. The key is whether you follow the proper procedure in making that decision.
And Dave, just to follow on that, you and I spoke even earlier this afternoon, right? There is a certain amount of what are appropriate considerations in considering changing providers and what aren't. The Department of Labor, I think, generally doesn't much care if it's going to be upset your corporate apple cart and cost you something necessarily as a corporation. But there are other factors like your employee morale and things that are more directly related to the plan. Do you have some?
Because we don't have any government agencies on the phone, I think the way I phrased it was I don't believe that the Department of Labor would consider the disruption on corporate staffing to be a permissible consideration.
Right.
So to the extent you decide that you want to stay with your current provider, that would not be part of your minutes. And so the content.
Yeah, no, but really, I think it is the Department of Labor considers certain expenses, certain problems to be problems of the settler, they would call it in trust terminology, and certain problems that are problems to the plan.
Correct.
And it's important to understand the difference. I mean, there are plenty of good reasons for not switching providers that are entirely appropriate. There are some that maybe the Department of Labor would challenge on. So as you put together your minutes, and I think it's entirely appropriate to document your reasons why, and you were saying as much previously, consider talking about with your provider, with your attorneys.
So, for example,
what are appropriate.
My current service provider is One America, and I did an RFP, and I found some other service provider that was a little less expensive, and I thought, I have a great relationship. Jamie always returns my calls on time. I am getting the best service possible. I think that it's okay to pay a higher fee and consider the service that's being provided to the plan participants and the continuity. So I know that the plan participants are going to have the same mutual funds that are going to be available, and it's going to cause less disruption for the plan participants. So the Department of Labor, that's what they're focused on, and they're going to look at your fiduciary duties under ERISA, the exclusive benefit. What I'm doing is acting for the exclusive benefit of the plan participants, acting in a prudent manner. To the extent I'm not an expert in a particular area, such as investments, I'm getting an investment advisor that's coming in and doing a comparison of this type of mutual fund versus other mutual funds, comparing performance, comparing fees, and making a prudent decision and documenting the reason for those decisions. That's what the Department of Labor is going to look at, procedure, not necessarily the end result.
That's right. Fiduciary is all about process, and it's all about documentation. It doesn't carry the day every day, but it sure gives you a better fighting chance.
I would say if you win the race, you're probably going to be okay.
Yeah,
but you want to have the procedure in place. So in hindsight, your decision always makes sense.
Right.
The IRS is going to look at, does your plan satisfy the qualification requirements under the Internal Revenue Code? Obviously, you recognize that in order to satisfy the qualification requirements under the code, your plan document has to say the right thing, and your operations, your administration has to be consistent with the Internal Revenue Code requirements and the plan document. I think it's several times throughout the discussion today, we've said the IRS may let you do this, but you also have to look at your plan document to make sure what you want to do is consistent with the terms in the document. So the IRS is going to be looking at, have you made amendments on a timely basis? Does the plan document comply with the legal requirements? And they're also going to look at administration. When clients get a letter either from the Department of Labor or the IRS, the initial reaction is concern, I must have done something wrong. Not necessarily the case. You may have just lost audit roulette. It may have been that you checked a box on the 5500, such as I've got delinquent deferrals. That might raise a red flag. The fact that the IRS or the Department of Labor send you a letter saying you're going to do it, they're going to perform an investigation, doesn't necessarily there's going to be a problem.
Well, that's right, Dave. And I think a lot of my experience, there's not just one kind of letter that comes from the Department of Labor. We have a client that we got a letter and it said they're doing a review. They have done, there's no allegation they've done anything. The Department of Labor routinely asks for a room full of documents. That's kind of their way. And you end up negotiating the documents you're going to provide and why these are relevant or irrelevant and how soon you're going to need them off of the department, and the IRS will give you an extension. They will send a different kind of letter when you are, a target's probably too strong of a word, but when they are specifically interested in you, and that letter tends to read, the department believes that either you or someone you know or someone we know it has or is about to commit a fiduciary breach. The wording of the letter is different. That secondary letter, that kind of letter, That one's a little, it's not necessarily concerning, but that should get your attention and it should be sort of promptly addressed. The first, not that the other one shouldn't, but I think the first one is a lost to audit roulette kind of letter.
My experience with auditors from both the Department of Labor and the IRS, I know that some of you, your experience is different. They have been reasonable.
That's right.
And you want to be straightforward. You're not trying to hide anything. That's obviously going to be a black mark if you try to hide something, because they're going to find it. So identify people with knowledge regarding the plan fiduciaries who can talk to the IRS or DOL representative. Provide the documents on a timely basis. Be responsive. One other thing that's just kind of a minor story, which is provide them with an office where they can conduct their business. I can remember one client saying, I want to make it as difficult for them as possible. I'm going to stick them in the cafeteria because...
And turn up the thermostat to 80 degrees.
What they didn't realize is a lot of their employees wandered over to see who this newcomer was going to be and said, what are you going to do here? Oh, you want to know about our plan?
No. Don't let the employees talk to them.
So provide them with a safe space, for lack of a better phrase.
Yeah, well, that's right. And I mean, I think a lot of you have the interview. I mean, it's not quite a deposition, but if someone's going to be going into an interview, have them walk through the kind of questions they're going to get. You want them to feel comfortable. You want them to be ready for it. You want them to be truthful and to present as truthful, not to present like they have something to hide. Because frankly, if there's something to hide, let's deal with it and let's get it taken care of and be able to tell the DOL, we found this, we dealt with it, by the way, but and here's the evidence. We took care of it.
I think that's what I was going to ask, Dave, is if, in your experience, if you've uncovered something while you're preparing for the audit that you know is an incorrect operation of the plan or something maybe the DOL is going to do, do I deliver that before they find it? Do I wait for them to find it and tell me what I've done to fix it? What
Good question,
do I do?
Jamie. A particular client, they had acquired businesses across the country. Unfortunately, they had a lot of different payroll sources. Some of those payroll sources were pretty timely in providing the 401k contributions. Some would do it every couple weeks or something like that. So when I sat down with the CFO to discuss this Department of Labor investigation, to say, how have you done things? And he said, well, it kind of depends, because those people out in California, they don't do a very good job. What we did is we sat down with the auditor. That was one where I was part of the conversation. We laid it all out. Again, my experience with the Department of Labor has been they've been reasonable. In that situation, they said, what we want you to do, we want you to go through, we want you to prepare an Excel spreadsheet that identifies when the monies were taken out, when they went in, how you're calculating earnings. We did that, we provided the evidence, and we said, this is what we came up with. The auditor even said, essentially she said, I'm not going to look at it. I ballparked it. You're in the ballpark. So that's going to be sufficient.
Yeah, I would add, and you've been saying all the same things, but be organized. When you give them everything they want, but have it organized.
Give them confidence that you know what you're doing.
Confidence. If you're disorganized and sloppy, they're going to think you're probably disorganized and sloppy with respect to the plan as well. So have the records. Give them everything they want, or an explanation as to why you can't. Mm-hmm. We've had situations where they've asked for volumes of information, and we've negotiated where maybe they just take a sample of things. But
it is negotiable. But that's a good point to kind of probably running out of time, wrap up on the issue. A lot of this stuff is negotiable with them. You have to talk to them. You have to say, and sometimes they'll tell you things and sometimes they won't. If they don't, they don't. But it never hurts to ask them, is there something specific we're working on here? I don't know, Shelley, how are we doing here? Looks like we're coming close to the end. So
we have 2 minutes. So with that, I just want to have the last slide just to maybe have some commentary with respect to participants. So participant accounts, missing participants, maybe talk about that. For those, because we will go a little past 3 o'clock, so for those that would like to stay on, we do have 1 or 2 questions that we will answer. So with that, Michael, just if you want to make some commentary on this.
One of the things, I mean, the interesting thing is that 90% of the information requested from a DOL auditor is the same from audit to audit. We can kind of tell you exactly what questions they will always ask.
Right.
It's the 10% that may be unique to your plan. But one of the things that's in the commonly asked category is, what are you doing about missing participants or vested terminated participants who haven't taken a distribution, or unresponsive participants that maybe you sent them a distribution, they didn't cash the check, and where is that money and how are you dealing with it? The DOL takes the position that you have to keep track of where your people are, even if they're no longer your people. If they're still participants in the plan, they're still participants in the plan. You have a fiduciary obligation with respect to them. So goal is to never misplace a participant. It's amazing how often it happens that people just don't keep track of their own money, and the employer then tries to have to figure out to do it. So if you've got missing participants, the rule is that you basically have to take reasonable steps to find them and make sure that they're aware that they've got money, and possibly even give them the opportunity to take a distribution. And it's not just a one-time thing. It's something you have to do periodically, because if you can't find them this year, you might be able to find them next year, or you might be able to find them the year after. There's no rule as to how often you have to do that, but I think the DOL is saying at least every couple of years. Unresponsive plan participants is a little bit different, because we've hashed this out in preparation for this. We've had some interesting discussions about, what do you do with the check that's not cashed? Because it's taken out of the plan, it's not invested, it's sitting in a distribution checking account, usually with your service provider. And how do you deal with it? And Mike and David, I'd like your perspective on, we've had situations where, maybe you should sheet that money to the state, and I know the Department of Labor doesn't like that. Do you put it back into the plan, and what are your obligations there? If you've got any insight on that, because I'll be honest with you, from a service provider perspective, it's somewhat perplexing, because it's difficult to get authority to do any one thing. So
my recommendation has been to put it back in the plan.
Okay.
Because it's been sitting in the One America distribution account. I'm not sure what you call it.
That's exactly what we call it.
Checking account, yeah.
Checking account.
So it's been sitting in your checking account, and should we just say it's One America's issue? I'm not going to worry about it. I've issued the 1099, so the individual should have realized it either because of the address on the 1099 or when they got audited by the IRS because they didn't put that line item, that distribution, on their 1040. Should we leave it with One America? And my recommendation is we should pull it back in the plan.
Okay. And it goes back in the plan after tax, because tax has already been paid on it. The employer, other fiduciaries of the plan have to make decisions as to what to do with it. Is it sit in cash? Does it sit in, do you invest it somehow? All issues that have to be resolved.
Do you forfeit it?
Do you put it in the forfeiture account is also sometimes an option.
Okay. Thank you, everyone, for joining us today. We hope that you found this informative. And again, very appreciate your attendance today. We do have one question, so if anyone wants to stay on the line, I think, Don, we have one question that was from earlier in the session.
We do have one question that came earlier as we were talking about temporary employees. And the question is, we have been told using temporary in our plan document is a red flag, and we should use another term for those associates whom we pay but are not considered permanent. What comments do you have, and do you have other terms that we should suggest?
We have a lot of comments and nothing that's going to be a slam dunk, I think, is the answer. And I know that sounds a little sort of facetious, but it comes down, in my view, subject to what you say, to can you demonstrate what the term means? The terminology, when you have terms that are kind of hot button terms like temporary, what does it mean? Have you administered it consistently? And have you administered it consistently in a way that shows it means something other than just someone who is expected to work less than 1,000 hours?
I think, some of our plan sponsors have come in, if you have that interview with them to kind of figure out who these employees are, like, do they do a specific job for you? Are they on a project? Are they really just project employees? You know, they're specific to a project. Sometimes that's the way to go. Delving in deeper and just trying to have that employer define solely what those employees
It's something you're going to want to have a conversation with your record keeper and maybe your attorney about. To what are they doing, right? To make sure a good term is chosen or is used, and one that isn't likely to raise a red flag. And even if it is, that you can show what it really means and that what it means is okay.
Yeah, and I would agree with all of that. I mean, I don't subscribe to the theory that certain words may be red flags. I think it depends on the auditor's true feeling that day. But I think temporary is that ambiguous word. So try to create a definition that doesn't use it, that actually is more meaningful, such as employees engaged for a project that is expected not to last longer than, pick a time frame, you know, or employees engaged for capacity reasons that are not expected to last longer than 6 months, so something like that. All I'm saying is you're hiring temporary employees. I'm just saying we're doing it because of a temporary need, but we're not going to call them temporary.
Okay. Thanks, Michael. We have one more question, though.
We do have an additional question, and this relates to the more recent discussion we had. Are there any specific guidelines for finding participants?
Jamie is a pro at it.
Well, I can say from One America's perspective, I help handle what we call abandoned plans and run them through the Department of Labor's abandoned plan program. So when you have that asset sale and you leave the plan behind and then nobody actually terminates it, eventually it may end up on my desk to get the participants in that plan paid out. And I know in the industry, and reading through articles that are recent, you know, a lot of the industry practitioners have asked the IRS and the DOL to issue specific guidance for us in finding missing participants. We understand it's an issue and we want to deal with it too, but we need your guidance so that we're doing what you expect of us. And so we have asked that. It has not been delivered. The best we have is a field assistance bulletin from the Department of Labor on terminating defined contribution plans, where, you know, they've laid out you need to send a certified mail to their last known address, search through your other records to see if you can find an address, try to contact known beneficiaries to see if they have a better address. There are a lot of free services online that you can search for people to try to narrow that down. And oftentimes there'll be multiple addresses, but you can send a certified mail to multiple addresses and see if one of those hits. So those are probably the best practices we have at this point in time.
And I think we have a follow-up to the temporary question. Go ahead.
The question is, would the term contract employee be a better word than temporary?
My take is it's the terminology is probably something that you're gonna might want to. It really comes down to what you're doing, and so it may be that the term contract employee is a somewhat less ambiguous term than temporary employee, because temporary employee can have the meaning of temporary short time versus temporary from a temp agency. And so if you're talking about people from a temp agency, maybe a contract employee is a fair description of them. I guess my ultimate advice on these kind of things is if you have this kind of contingent workforce sort of situation, it's best to talk that over with your record keeper, with your attorneys, whatever. Make sure that it's addressed properly in your plan. And Michael, Jamie.
Yeah, contract employee is just another term that you still have to define. So it's the definition that's going to matter as much. I would caution when you say contract employee, sometimes people being an independent contractor, and that's a different animal entirely. And there are rules as to who's an employee versus who's an independent contractor. And if you get it wrong, it can be very expensive.
Right.
Okay. With that, again, thank you very much. For those of you that are looking to obtain your CLE credits, again, take a look at the form that's on the dashboard. Those of you that are doing the HR certification, there's a form for you, and that's self-reporting. So thank you very much. We've enjoyed spending some time with you today. So thank you.